Hello and welcome to our webinar today. Today's webinar comes with the reserved apologies for the delay from last week's schedule, which was to allow our attendees to witness England's progression to the euro. So we are here today, ready to deliver our webinar now on the topic of AI and the European Commission's AI regulation proposal, and also to help us consider whether this will stop the rise of the robots. So who's going to be presenting to you today? My name is Vin Banj. I'm head of our data and cyber practice, and I'm going to be joined by my fellow expert colleagues. There's Helen Farr, who is a partner and specialist in employment law, and also where data privacy intersects in that particular area. And also joined by Debbie Haywood, who is a senior professional support lawyer for our technology and data practice. And also well-versed in the developing law and expertise around technology and data and cyber. So we three will be presenting to you today on this particular topic. So this webinar is part of our data protection practice webinars, our global data hub. And as we go through the presentation today, you will see a lot of similarity and a lot of connection points that make you think, that sounds a little bit like GDPR, or that sounds a little bit like data. And so we felt it was totally right that this new topic came from the international data protection practice to bring this particular development to you. So just a little bit about international data protection practice whilst we have this slide at this stage. And our regular attendees will be very well aware of our international data and cyber practice, where we advise on aspects of data privacy across our footprint and also beyond, to give you a global one-stop shop support offering around data and cyber. There's much more details on the slide, and also much more information about that for you to see at leisure on our global data hub. The global data hub is a dedicated microsite on which you can find all things data privacy and cybersecurity. You'll find access to our different tools and products, our articles on developments in this area, our thought leadership, where we post and will house our news and webinars, and also our events, such as this today and our events that we've had. There is a huge virtual bank of webinars for you to be able to access through the Global Data Hub portal. I mentioned tools and products through the Global Data Hub. You'll also be able to access the Global Data Protection Guide, which is a guide that allows you to slice key considerations of data laws across 65 countries and allow you to compare and contrast, so you have that high-level visibility on that data landscape. And also very topical, given the recent mass cyber attack that we've heard in the news over the weekend and still running at the moment. We have access to products and tools such as our cyber response app. So that's all available for you to access through the Global Data Hub. So back to the topic of the day. What is our agenda? Well, I guess in some ways, with our topic title, Will the AI regulation stop the rise of the robots? We may be years away from truly understanding what impact this regulation has on the robot community, but we have to start somewhere, and that's what we're going to be doing today by introducing this regulation and starting to look at what this is all about. And in a moment, I'm going to hand over to Debbie, who's going to walk through an introduction of the AI regulation to warm you up to what it's really all about. Then we're going to try and have a look at this from two different perspectives. Then Helen is going to look at this from the impact for the HR environment, and also look at how AI is increasing in the people and HR environment, and also looking at aspects of automation and sharing her views from that particular perspective. Then it's going to be back to me, and I'm going to try and apply just some industry context and dig a little bit deeper on top of the introduction that Debbie's going to give. And I'm going to do that against the backdrop of life sciences. So just looking at it from an industry perspective, So we can just try and see and toy a few of the aspects of this regulation and see how that begins to shed light in terms of applying it in context. Then, as we regularly do in these webinars, we're going to move on to some polling questions at the end, and we'd love for you to click away and give us your views on those polling questions. Remember, as always, for the polling questions, it's the aggregate view that we're going to report, and we'll report that to you so you can see it, hopefully just a few minutes after you've all finished clicking away at the options. But please do take part in that. It allows you, your fellow attendees and listeners today to get a feel for some of those questions, particularly around readiness and testing some of the points of awareness that we're going to try and cover today. That's the agenda, quite a lot to cover. So let's get started and see what this is all about. So as an introduction first, let me hand over to Debbie, who's going to introduce you to the new AI regulation. Debbie, over to you.
Thanks, Vin. Yes, as Vin said, I'm just going to run through what the regulation does and look at how it's set out. Wanting to say it's still pretty early on in the legislative process. But it, as Vin sort of alluded to, one of the striking things when you read this regulation is that although there are question marks over the way things are defined and how closely they're defined, if you're familiar with the GDPR, you will understand where the Commission is coming from on this. There are lots of very familiar concepts, for example, around territorial scope, regulation and enforcement, transparency and reporting, cybersecurity, data governance, and in particular, a risk-based approach. And that's very much the type of approach we're seeing in fast-moving areas, not just in the EU, but also in the UK, for example, with the UK's online safety bill. They're trying to future-proof the regulation by putting the emphasis on this kind of risk analysis. And so a lot of the concepts in this regulation are familiar, even if the technology may not be. So I'm just going to look at what the regulation covers. Basically, its aim is to produce harmonised rules for developing AI systems, placing them onto the market and using them in the EU. Certain types of AI are categorised as posing unacceptable risk, and they are banned. The next tier down, you have high-risk AI systems, and that's really where the majority of the obligations lie. So it's really, most of the obligations relate to people who are involved with high-risk AI systems. Limited risk systems are subject to transparency requirements, and minimal risk AI is not subject to regulation at all, but there is scope to have practice codes. So the AI regulation is going to apply to providers placing AI systems on the EU market or putting them into service regardless of where they're based. And again, that's a familiar concept in the GDPR. It will also apply to users of the AI systems located in the EU and to providers and users of AI systems located in a third country where the output produced by the system is used in the EU. So what exactly do we mean by AI system? Well, I don't know what I mean by AI system, but what the EC means by an AI system is that it's software developed with one or more techniques listed in the annex to the regulation, and that can, for a given set of human-defined objectives, generate outputs like content, predictions, recommendations, or decisions which influence the environments they interact with. That's quite a mouthful, and when you add it onto the sort of the criteria in Annex 1, it can become quite complicated to decide what's going on, and I think that's one of the criticisms with the current draft. So let's start with unacceptable risk AI, and this is the sort of the scary futuristic stuff, some of which actually is already exists, but this is the stuff that regulators around the world are really trying to make sure they deal with, and that basically that we don't have the robots taking over the world. And it sounds barely credible, but we are moving so so quickly in this area that it's right that that the governments are trying to allow for this kind of future risk. So it's an outright ban on unacceptable risk. AI uses which are, that's basically AI uses which are considered to violate fundamental rights, and they're set out in Title 2 of the regulation, but the regulation allows for these to be amended from time to time. So that means that the regulation will adapt and flex to the technology as it develops. But currently, the kinds of technology we're talking about in terms of high risk are AI systems which deploy subliminal techniques beyond a person's consciousness to materially distort a person's behaviour in a manner that causes or is likely to cause them or another person physical or psychological harm. Similarly, technologies which exploit vulnerabilities of a specific group, for example, due to their age or physical or mental disability, in such a way that it materially distorts their behaviour and causes harm, that will come into the unacceptable risk category. Risks of social trust systems, so systems which evaluate the trustworthiness of individuals over a period of time based on their social behaviour or predicted personal or personality characteristics, which give them a social score, and that leads to detrimental or unfavourable treatment of an individual or group in contexts which are unrelated to those in which the data was originally collected. And that's again a bit of a mouthful, but you can see social trust systems already in place. For example, in Xinjiang in China, they use that, and you can basically accrue points which allow you to get petrol depending on what your social score rating is. So that these systems are in use, and can have very real implications on people's lives. Now, one of the more controversial areas is high-risk AI is also considered to include real-time remote biometric identification systems in publicly accessible spaces. So we're talking about mostly about facial recognition for law enforcement purposes. But there are quite considerable caveats and exceptions to this ban, which are controversial. And so, for example, where the system is being used where it's strictly necessary to achieve targeted searches for potential victims of crime, including missing children, or to prevent substantial and imminent threat to life or terrorist attack, there are exemptions from the ban for using that type of high-risk AI. The regulation defines high-risk AI systems as systems which have an adverse impact on people's safety or their fundamental rights. And this includes where the system is intended to be used as a safety component of a product or is itself a product covered essentially by product safety legislation, or where the product whose safety component is the AI system or the AI system itself as a product is required to undergo a third-party conformity assessment with a view to placing it on the EU market or putting it into service. And that's, again, pursuant to legislation which is set out in one of the annexes, but it's broadly product safety legislation. So it's Annex 3 that gives a sort of non-exhaustive list of high-risk AI systems. And these systems, remember, these are the ones that are going to be subject to most of the obligations in the regulation. They include real-time and and remote biometric ID systems like facial recognition technology. They include credit scoring systems, AI systems which are known to contain bias. For example, the example that was given about was the public exam algorithm that was used last summer to predict A-level and GCSE results with unexpected consequences. And systems to assess eligibility for welfare or legal aid, and again, and AI for recruitment, which Helen will be talking about more later on. So what happens if you are using an AI system, a high-risk AI system? What rules will you be subject to? Essentially, there's a continuous iterative risk management system which runs for the life cycle of the AI system. There are data and data governance requirements, which Finn will talk about. You have to produce technical documentation. You have to keep records. There are transparency and information provisions. All of that will sound familiar again if you are familiar with the GDPR. There's also a requirement to have human oversight on the systems for obvious reasons, and to have controls on their accuracy and over cyber security. And the obligations are quite extensive. I'll summarise them very quickly, but this is a lengthy piece of legislation. So various stakeholders, including providers, importers, distributors and users of high-risk systems, are subject to individual requirements. And this broadly involves getting the system through a conformity assessment and applying a CE marking to indicate conformity with the regulation. So it's quite a complex equivalent, analogous to a product safety process. As you'd expect, the regulation isn't going to work unless it's got teeth, and there is a pretty comprehensive regulatory and enforcement regime in the regulation. Again, some of this will be familiar to people who understand the GDPR, but there is a big difference in that there is no one-stop equivalent to the one-stop shop mechanism. So a lot of the enforcement is done at member state level, although there is provision to create a European Artificial Intelligence Board, and that board will be comprised of member state regulators and will be responsible for producing guidance in much the same way that the EDPB does now for data protection matters. There's a range of sanctions and sweeping penalties of up to 6% of annual global turnover for breaches. I'm not going to talk about it in detail, but there are also provisions which are designed to encourage development of AI. So you've got most of the regulation talking about how to restrict or how to regulate AI, but there's also an element of encouraging the development of AI systems. So just very briefly, I'm going to pick out some of the talking points around this so far. I think it's fair to say there's some difficulty with the definitions, in particular the definition of AI systems, and also how to differentiate between high and low risk systems. There's a lack of clarity around some of the user obligations because they have to be determined on a case-by-case basis. And I think, as we saw with the GDPR, a lot of the detail will be hopefully will be filled out by guidance. And so until we see that guidance, it's not always easy to know exactly how this is going to work in practice. As I mentioned, there's a lack of a one-stop regulatory mechanism, and that's caused concern that there'll be a lack of harmonisation, despite this being an EU-level regulation. And then you've got two schools of thought. I mean, some commentators say the measures go too far and they'll stifle innovation. You probably predictably, these are often the business users. And then you've also got a lot of people arguing that these measures don't go far enough. And interestingly, the EDPB has called for an outright ban on facial recognition technology and doesn't agree with the way it's categorised in the regulations. So it will be interesting to see whether that changes as the regulation progresses. So just worth pointing out, the regulation won't apply in the UK, but its wide territorial scope means it will obviously impact UK businesses placing AI products on the EU market, using them in the EU and providing output from AI which is used in the EU. So it's very relevant even if you think to a wide range of UK businesses. Alongside that, we're expecting to see the UK develop its own framework, so we'll have to wait and see how far that mirrors the regulation. And we're also, as I said, going to be waiting for guidance to see how this is fleshed out. But the legislation is in its infancy, and it may well change as it moves through towards enactment. And as we know from, for example, from the e-privacy regulation, this type of legislation can take a very long time to come in. So with this fast-moving technology, a risk-based approach seems sensible. But I mean, I think the message for now is, this is a good indication of the direction of travel. It's not the final word, and we will, of course, have to wait for the final regulation to understand that completely. But because this is all very complex, it's definitely worth thinking about it now and watching to see how this progresses. So I'm now going to hand over to Helen, who's going to talk about the HR aspect.
Thanks, Debbie, and can I start by saying a really good afternoon to everyone. As Vin has explained, I'm a partner in the employment team, but I do loads of work with Vin and the privacy team on the sort of HR privacy crossover issues. Great to be here this afternoon to be talking to you about those issues that apply if you are either using AI or thinking about using AI in the workplace as an HR tool. So what am I going to cover this afternoon? I'm going to look at three key areas. I think Debbie's already brilliantly articulated how well and how important the issues relating to AI are and the impact that they're having on business. What impact is that having on the workplace? How are businesses using AI? And of course, we're expecting the EC regulation on AI, but there's already in place a current legal framework that you do need to be aware of if you're thinking about or are already using AI in the workplace. So how big an impact is this, the use of AI going to have in the workplace? And are we really facing what's been described 5 years ago by Klaus Schwab as the fourth industrial revolution? Well, certainly there's been loads of hype about the use of AI in the workplace. There's been a lot of commentary, and certainly I think as an employment lawyer, absolutely the pandemic's having huge impacts on the way we work, but perhaps a more significant impact on the way we work and the way we live and relate to one another is going to be the use of AI in the workplace. And because of that, it's absolutely essential employers use these tools correctly and appropriately and are absolutely aware of the legal framework that applies at the moment and is likely to apply as the law develops in this area to keep pace with such a rapidly developing area of policy. So what are we seeing in the workplace? How is AI used in employment? And I think the starting point is that, maybe 5 years ago when this topic was being looked at, I think the commentary I was seeing and discussions I was having with clients were all about, robots taking over jobs. But actually, when you think about the definition of AI, what it really means is the science of making machines smart. And I think that's fundamental to the heart to what we're seeing in the employment context. What we're seeing is rather than machines replacing jobs, we're seeing much more use of machine learning algorithms to actually take away or deal with some of the management aspects of workplace relationships. So, as Debbie's explained, one of the key areas in which AI is commonly used and is increasingly being used is recruitment. But it's being used in a much broader context than that. We're seeing businesses using AI algorithms to decide who should be fired. We're seeing people using AI to deal with a number of line management issues, including setting people's appraisal grades, dealing with disciplinary issues, performance management. Learning and development is becoming increasingly dealt with by robots. And an interesting development during the pandemic is the use of AI tools to monitor staff. And for those of you who are interested in this, I would absolutely commend you to read the TUC's report published last November called the Worker Experience Report. And that's got some really interesting stats in terms of how businesses are currently using AI. And what you can see from that is that 22% of those who completed the report confirmed that they were using tech for things like absence management. 15% were using it to give grades, appraisal ratings. A number of employers were using it, over 20% for work allocation, timetable and shift. But slightly scarily, and perhaps more concerningly, and this is where I think we need to look at the legal framework, is that when the TUC asked employees the question, is it possible that decisions are being made about you using AI-powered technology, many of them said that they suspected it was the case. but that they weren't and they hadn't been informed about it by their employer. And that was quite dramatic. 89% of those surveyed said yes, they believed that there were decisions being taken by computers about their employment, but they hadn't been told. I think that's quite an interesting statistic and something that we need to bear in mind. I think the starting point is that in the employment context, when you stop to think about it, AI will always be using personal data. And that applies from the systems and processes that are used to train and test AI models, because what the developers will do is they will take vast amounts of personal data, often taken from previous or existing employees, to train and test the algorithm to ensure that it comes up with a result that is in line with the expectations of your business. And that can be, as I said, ranging from decisions about recruitment through to firing or performance appraisals. But actually, when that the decision is being made using the algorithm, again, you should be aware and don't forget that that on deployment personal data is being used to create decisions about individuals. But the starting point is that whenever you are using AI to make decisions, data protection, the GDPR principles will apply, the Data Protection Act will apply, and so there's a risk of breach of those principles. And I think because so many businesses have not been fully cognizant of that, last July the OCO published guidance on AI and data protection to act as a guide to those who are implementing AI projects and to ensure that you do so in a compliant way. And I've put on the slides a number of questions that you need to think about, and Ben will be talking about this in a lot more detail, but I think the fundamental point here is to be open and transparent with employees in particular about the uses of AI processes in the workplace, or you're likely to fall foul of the Data Protection Act and GDPR principles. I think a more fundamental employment risk is the risk of bias in automated decision making. And I'm sure lots of you are thinking, that's fine, Helen, but how can a computer be biased? How can an algorithm be biased? And in fact, I think over recent years, there's been a lot of sort of almost a view that it's much better to have decision making being taken by an algorithm than a person, because it removes that possibility for individual biases or be it conscious or unconscious or stereotypical behaviour to play out in key employment decisions. But in fact, and slightly alarmingly, we're starting to see already a number of cases where AI, the use of AI, absolutely isn't eliminating the risk of bias. And the reason for that is because the way that the systems work is, as I've said, they take a huge amount of data, usually from the organisation. The computers sort of develop a right or a wrong answer or selection criteria based on the information that they have from previous decisions, and they perhaps will make a link between a protected characteristic and a sort of future prediction about future behaviour. And an example of that is in the States, where judges used an algorithm to use sentencing decisions, and the algorithm learned a discriminatory correlation between race and the likelihood of reoffending. And so when the algorithm has been used for a number of months, it soon became clear that black offenders were given longer sentences than white offenders committing a similar crime. So that's an example of how bias can play out in practice. And I think if you think about the way that automated recruitment processes are developing, we're starting to see computers targeting job adverts, computers making the decision about who should be selected through to interview stage. Computers are now commonly doing background checks, and we're even seeing computers undertaking interviews and scoring candidates, which is a massive development. So if you're in that scenario and you're an individual who believes that you've been discriminated against as a result of the sort of an unconscious bias or a bias that's been perpetrated by a computer, what remedy do you have? Well, in fact, you have the same remedy as you would if you've been discriminated against by a person. You are still entitled to bring a claim under the Equality Act if you can show that you have a protected characteristic and that you have been subject to unlawful prohibited conduct, and the remedy is unlimited compensation. And the way that plays out, I've set out the legal test on the slide, but basically if you can show that, say, for example, during an interview process, the company has applied a provision, criterion of practice which is discriminatory, and has a discriminatory impact against you because you're black, because you're female, and you would have an ability to claim what's called indirect discrimination. And how that works, a common example of how indirect discrimination could work in an employment context is, if as an employer you advertise a job and it's only for full-time staff, you won't count applications from anyone working on a part-time basis, that's likely to have an indirectly discriminatory impact on women who are less likely to be able to work full-time because of care and responsibilities. So in the context of AI, and what's starting to come through the cases is that both an algorithm and a database that's used to train the algorithm is likely to be a PCP. So looking at an example of a real-life case where indirect discrimination occurred in practice, a case that was handed down last December in Italy by the court in Bologna against the Italian Deliveroo company. What they did was they used an app to assess the priority it afforded when the company's riders in relation to access to jobs. And it came up with a scoring system based on, drivers' reliability, flexibility, and in practice that might seem completely reasonable and without risk of discrimination at all. But the impact of that app was that more women than men were deprived of jobs, and that was because, for very good reasons, women were often unable to attend to work because they had caring responsibilities, or they needed to have more fixed hours. They couldn't be as flexible as some of their male contemporaries. And so the conclusion of the court was that the use of this app did have an indirectly discriminatory impact on the workforce, and Deliveroo is now no longer using it. I think perhaps a really current use of AI is with the automated online monitoring of employees. And I put on the slide this quote or headline from the BBC News channel from September last year, with a business leader saying, "I monitor my staff with software that takes screenshots," which is just one example of how AI is being used. Other examples I've set out on the slides include a number of keystrokes an hour, tools that are used to log hours. Some are more intrusive than others. But I think it's certainly true to say that what I'm seeing is a much more of an increased focus on using automated monitoring, especially during the pandemic. Again, what remedies do you actually have in that scenario? Well, I think you do need to be aware that if you are using surveillance while people are working at home, they may well have rights under the Human Rights Act, in particular the breach of the right to privacy. And if you think about some of the environments that people are working in, it's certainly the case that they can, there may well be breaches of the Human Rights Act, and they still apply even though we've left despite Brexit. The other point to bear in mind is, again, the potential breach of the GDPR and Data Protection Act, and you need to be careful that you do have a lawful reason for monitoring as well. How is AI playing out? So just to wrap up, I think what I wanted just to finish up with is just to say, look, you know, as Debbie and Vin have said, the use of AI is increasing so quickly and dramatically. And just over the last 6 months, we're starting to see a raft of cases where AI is hitting the news. Unfortunately, we've been the victim of sort of unfavourable commentary in respect to the fact that they're using AI to undertake dismissals, which are alleged to be unfair. They've also been accused of using facial software that, because it doesn't recognise black facial characteristics, is having indirectly discriminatory impacts on the drivers. And that was as recently ago as March. I think that this is an area that's going to just increase, and you do need to be really careful and think very carefully about how you implement AI if it's something that you're going to do. And I'm sure all of those of you who are listening will be. So what should you do? Well, just to final wrap up, that you need to have a people strategy for AI and automation. You need to make sure that your HR advisors, your HR leaders are at the top table on this, so they've got just as much a role to play as those working in operations and your technology teams. I think it's absolutely fundamental to keep your employees involved and updated. They need to understand and be consulted about the new system so that they understand how they work, and there's a reduction in any potential for glitches. Learning and development, absolutely people need to understand and be able to keep pace with the fast rise of tech. Transparency and openness, I think, is incredibly important, and it's important because it will avoid potential for risks of claims under the GDPR and the Data Protection Act, and also potentially the Human Rights Act. And finally, do be alive to that risk of indirect discrimination. You know, there are still, and there is a potential for bias if you are using algorithms to make decisions, and do take advice, because from a financial and a reputational perspective, you really don't want to get this wrong. Now I'm going to hand over to Vin, who's going to be looking at data protection issues, and in particular looking at life sciences. Thanks, Vin.
Thank you very much, Helen. An awful lot to take on board there. Yeah, so I'm just going to have a look at this again. So apologies if this sounds like I'm recapping, but I'm going to try and just go over what we've looked at, but look at this with a flavour of life sciences. And as Debbie mentioned, the AI regulation and what you would have heard there is, it's a first. It's the first time that we're seeing this type of proposal for a law that seeks to introduce a comprehensive, harmonized regulatory framework for AI, specifically for artificial intelligence. And obviously, as we've heard, it comes with a significant sting in the tail if you get it wrong, the financial penalties that we talked about as well. So as an organization, you will need to understand the scope of the AI regulation. And in a moment, I'm just going to explore with this flavor of life sciences. And even if you're not a life sciences business, hopefully this will help with the thought processes on how the AI regulation might apply to your business. And just as I've said the word scope, maybe we'll just focus on the word scope for just for a few moments, because the scope of the AI regulation, as Debbie mentioned, is broad. It's designed specifically to cover the life cycle of the development, the sale, the use of AI systems. This includes, for example, placing AI systems onto the market. Includes putting AI systems into the service, and also making use of AI systems. So all those involved in these sorts of activities, whether as a provider, a user, a distributor, an importer, or resellers even, they'll be exposed to at least some regulatory scrutiny. This is also an issue that brings about extraterritorial considerations. So if you have a nature to your business, then this will extend in its application to providers or users of AI systems who are located outside the EU, if they are placing their systems into service in the EU, or using the outputs derived from the AI systems that are being operated in the EU. So it's no surprise, whereas we've mentioned that the AI regulation sits alongside many familiar legal points that we've mentioned already. For example, we've mentioned that this sits alongside GDPR. The AI regulation is clearly and deliberately designed to complement and to work alongside, and whether by design or not, it does intertwine itself across several existing legal frameworks. For example, product safety and CE regime, which is obviously very important to medical devices, for example, and also the broader regulation of medical devices and that particular regime. And of course, as we've said, data protection under GDPR. Even though at the moment this is a proposal, we can clearly see the direction of travel for regulating AI, and we see that in the definitions that Debbie mentioned earlier on. And the definition of the AI system is clearly intended to be technology neutral, or that was the intention, and therefore it's designed to be, again, the intention is that it's going to be future-proofed from that particular perspective. And it's clear when you start to look at the regulation from that perspective that there are so many parallels with what we see in the regulation and how it's appeared in the proposal, with, for example, the work of the OECD's recommendations and its body of work around regulating AI. So when you see definitions that focus on software, when you see that it's software that's developed with one more of the specified techniques and approaches, and these are set out in Annex of the AI regulation. And when it talks about these techniques that include, for example, machine learning approaches, or logic and knowledge-based approaches, and statistical approaches, and some of those examples that Helen mentioned will quite neatly start to fall into these categories. And showing that this is all about software that can, for a given set of human-defined objectives, and I'm quoting from the regulation here, generate output, and it's output such as content, predictions, recommendations, or decisions that influence the environments that they interact with. Now, when you look at it from that perspective, it's quite clear this regulation will impact on the use of AI in sectors that are data-rich and technology-rich and AI-rich, such as life sciences, but also many other sectors as well. And when you start to look at it from that perspective, and as you look at the AI regulation, it becomes clearer that it impacts on some parts of the sector, perhaps more than others, or the examples start to jump out more. So take, for example, medical devices and health tech. Any AI that constitutes a regulated medical device or is used as a safety component of a medical device is classified as a high-risk AI system, and I'm going to talk about that in a moment. This is especially relevant given the huge growth of software as a medical device and the explicit reference to software in the definition of a medical device under the regimes that this sector in particular is already familiar with, such as the MDR, the medical device regulation, and also the in vitro device regulation, the IVDR. So the overlaps become quite apparent there already. And so a developer of such a device, which the AI regulation refers to as the provider, has to comply with a framework of obligations, as Debbie mentioned earlier. And the requirements that are applicable, particularly to high-risk AI systems, again, very relevant to this sector, given what falls under the definition of a high-risk AI system. Again, I'm going to look at that in a moment because it's important to explore some of the depths of those definitions and what's involved and the parallels that we see in other legal reference points. Importantly, however, the EU proposal is for the requirements for AI systems to be checked as part of the existing conformity assessment procedures, as David mentioned, under the medical devices regulations. So again, another touch point with this particular sector. And in this, the AI conformity assessment will therefore be an extension of the medical devices assessment regime, with the clear aim of the EU seeking consistency, trying to avoid duplication, and minimize additional burdens. That's the aim. I'm not totally convinced that that aim is going to be met, and for reasons that will start to become clear as I work through the next slide or two. The AI regulation establishes a comprehensive regime for both post-market monitoring and market surveillance. It makes clear that the market surveillance authority in each member state, with responsibility for medical devices, will also have competency in respect to market surveillance of AI in relation to those devices. And in addition, the AI regulation requires the creation of a new supervisory authority, as Debbie mentioned, and that will be responsible for providing guidance and advice on the implementation of the AI regulation, not just for life sciences, but actually across all sectors. AI systems already play a noticeable part of, for example, the pharmaceutical industry. For example, drug discovery, the interpretation and analysis of clinical data, and the selection, for example, of patients for a clinical trial. All of these activities rely quite heavily in so many environments within pharmaceuticals on AI, or AI as an integral part of that. So it's important to note that as well as AI-based medical devices, some of these other uses of AI by the pharma industry in particular may fall into this high-risk status. Of course, it depends on the list of fields set out in Annex 3 as to what falls within this high-risk status. And we can already see that aspects of processing of, for example, patient data can constitute the biometric identification and categorization of natural persons, and bringing that firmly within scope here as well. It's really key to note that pharma companies, like any other employers, and Helen has spoken about this already, so I'm not going to cover this in any details, could also stray into this high-risk territory when using AI for recruitment, or to make those decisions such as promotion, termination, or employee management. Of course, AI solutions used by the pharma industry may otherwise amount to a lower risk if they don't fall under the higher risk. And I'm going to explain in a moment what triggers a lighter framework and why that lighter framework will focus on transparency requirements. Let's just dig a little bit deeper when we're talking about this framework and what the framework is actually designed to do. So we both mentioned prohibited AI practices, and we've talked about that a lot. There are prohibitions to be very much aware of, and it is so easy to see how tech, big tech in particular, or life sciences and big pharma in particular, may find itself close to some of these environments. So these are areas that may be otherwise construed as violating fundamental rights of individuals. So use of AI within, for example, AI-based dark patterns, the systems that deploy these subliminal techniques that may materially distort a person's behavior, or is likely to cause that person or another person physical or psychological harm in quite significant output and impact. So you can see why these are prohibited practices. And also AI-based micro-targeting, so AI systems that exploit the vulnerabilities of a specific group. Again, focus on outputs such as those that will cause or may cause physical or psychological harm. So prohibited practices are absolutely a point to be assessed and addressed when you're looking at your AI landscape. High-risk AI systems, mentioned this a few times, so let's just dig into this a little bit deeper. High-risk AI systems are permitted as long as strict controls that are set out in the AI regulation are put in place to mitigate this high risk. And a lot of this part of the AI regulation follows the approach taken in existing EU legislation to manage, for example, issues such as product safety risk. It's all about managing and mitigating risk, except the AI regulation, as you'd expect, actually goes into a bit more detail around what this really means and what's expected. High-risk AI systems are, and Debbie touched on this earlier, defined by a classification model. So we have a classification model that also allows you to focus on the risk that's associated with the product itself. This regulatory control environment is applicable for high-risk AI systems. Well, these fall on providers of the system itself. So this includes obligations and a framework around transparency, around security, around accountability, around risk management, testing, and also, and this is quite important, human oversight. Let's just take a look at some of these in turn, because there's so much here that is new on one hand, but also so much that is actually very familiar with, for example, what we see already set out in the ICO's framework, albeit that's quite high level, but you'll see the common touch points here. So transparency. High-risk AI systems must be designed and developed in such a way to ensure that operation is sufficiently transparent to enable users to interpret the system's output and use it appropriately. So clear user documentation and instructions should be provided to the user of the AI, which must contain information on the identity of the provider, the characteristics, the capabilities, the limitations of the AI system, and also what constitutes the human oversight measures. In terms of security, a high level of accuracy, robustness, and security must consistently be ensured throughout the high-risk AI system's life cycle. That's about the whole life cycle. And serious incidents and malfunctioning of the high-risk AI system must be reported to the market surveillance authorities of the member state where the incident occurred. So big questions start to jump out already, and probably questions we can't answer right now in terms of, well, could this involve dual reporting if there is personal data that's also impacted as far as accuracy, robustness, and security is concerned. Accountability is quite a key point here to note as well. So there are important aspects of accountability that need to be borne in mind. So complete and up-to-date technical documentation must be maintained and drawn up by the providers before the placement on the market or putting into service of the AI to demonstrate compliance with this AI regulation. The outputs of the high-risk AI system must be verifiable and traceable throughout the life cycle, including the automatic generation of logs, which must be kept by providers when it's under their control. So you're already beginning to see what needs to be demonstrated to show compliance with the regulation. The system must be registered, as Debbie mentioned earlier on, in an EU database on high-risk AI systems. So now we're beginning to talk about registration, an EU database of high-risk AI systems. Where there's no importer that can be identified, then an accountability principle here makes clear that providers established outside of the EU should appoint an authorized representative. So again, parallels begin to jump out with GDPR. Parallels begin to jump out when you look at, for example, the ICO's proposed approach and framework towards AI. Risk management systems must be established, implemented, documented, and maintained as part of an overall quality management system. And risk management must comprise a continuous iterative process that runs through the entire life cycle of the system. Testing is important. Any data sets used to support training, validation, and testing must be subject to appropriate data governance and management practices, and therefore they must be relevant, representative, and free of errors and complete, and have the appropriate statistical properties to support the use of the AI system. And human review is very, very important. AI systems must be designed and developed in such a way that there is effective human oversight, and this is something that needs to be read into because this will impact quite heavily, particularly around challenges such as the use of the systems in accordance with the instructions that have been provided by the provider, ensuring that all input data is relevant to the intended purpose, monitoring the operation of the system and informing the provider distributor of suspected risks or serious incidents or malfunctioning, and keeping logs that are automatically generated by that high-risk system. again, a lot of parallels here with the governance and accountability system under GDPR. There are, of course, other rules, particularly rules that are triggered for low-risk AI systems, and these are predominantly based around transparency. So these are really transparency-driven requirements. But what's really important about low-risk AI systems and these rules that are set out in the regulation is that the minimum requirement is transparency. There is still an expectation that you look to the requirements set out in the high-risk system requirements and be able to at least point upwards rather than have a ceiling of purely addressing transparency. So a lot of effort here. Do we really need to comply with all of this because you're using AI? Well, there's a lot of points that are going to be very, very relevant here. So enforcement, we mentioned the European Artificial Intelligence Board. The AI regulation provides for the establishment of the European Artificial Intelligence Board. And the EAIB will advise and assist the EC in the European Commission in relation to matters covered by the AI regulation. You can already see how the construct here is clearly modeled on the tactics and responsibilities of the European Data Protection Board, the EDPB, under the General Data Protection Regulation, under the GDPR. There is also going to be a role for national competent authorities, a national supervisory authority responsible for providing guidance on the implementation of the AI regulation. The AI regulation requires member states authorities to conduct market surveillance and control of AI systems in the product safety regime. So control, validation, cooperation begins to play a deeper part as far as enforcement is concerned. And if the market surveillance by an authority gives reason to believe that an AI system presents a risk to the health or safety or the protection of fundamental rights of persons because of the use of the AI, the authority shall carry out an evaluation of the AI system and, where necessary, require corrective action. So we're already beginning to look at a role of assessment, maybe even a role of audit, and maybe even a role of demanding corrective actions, although we don't yet know exactly how that will manifest itself. And obviously, we talked about this thing in the tail, the turnover-based fine that is possible here. And we don't know quite where it's going to land, but somewhere between 2 and 6% of the global annual turnover. What's interesting here is the AI regulation is going to be enforced by supervisory authorities and does not provide for a complaint system or direct enforcement rights for individuals, unlike GDPR. But of course, AI only exists by crunching through data and not quite often personal data. And therefore, individuals do have rights in personal data. So you can see how actually you'll start to see potentially a blurring of the distinction in terms of which regulator is going to enforce the impact and output of an AI system where there is a detrimental impact because of the processing of personal data. So a lot that we've covered here. And as the outline that was presented hopefully will demonstrate, the AI regulation will impact many sectors, not just the examples that I've skirted over in the last few minutes around pharma and life sciences, but especially as we're seeing further increased use of AI across so many business areas, we will start to see more direct impacts of how this regulation begins to apply. And the big question here, I appreciate we're coming up against time, but are we ready for this? Is industry ready for this? Is this regulation, although it's just a proposal, is this being lost in the noise? Of course, there's plenty of competition for attention at the moment, whether it's adequacy, whether it's the new standard contractual clauses, whether it's how to comply with the SREMS requirements and data transfer impact assessments, and GDPR fines, et cetera, But let's just look for a moment, if we can, on some of the polling questions. We'd love to gain your views, which we'll share back as you click along. So first question is, are you using AI to monitor your employees? And I'd love to know if you have a clear answer to that, yes or no. Are you using AI to monitor your employees? And you would have seen the examples that was mentioned earlier on by Helen in terms of there's so many different ways that this can impact in the people environment. So, oh, wow. So far, and I know this is just a limited poll, but the answer there looks like a no, which surprises me. But as we go on, I'll be interested to see how that compares with what we are seeing so far, particularly against knowledge of how AI systems work more across your organizations. Just before I do flip forward, Helen, does this surprise you?
Yeah, I think it does actually, Ben, because we're seeing across the board a lot more use of systems to monitor employees. So yeah, it's definitely quite surprising, and it's an interesting result, I think.
Okay. Well, I thought you said that. Let's just see how it compares with a couple more questions that we have here. So, would the proposal on the draft AI regulation change how you use AI in a HR context? I guess the answer really should be no here, because it's 100% of those of you who clicked away a moment ago thought that you are not using AI. Then how does this impact on what you are doing? How will the proposals in the draft AI regulation change how you use AI in a HR context? Please do click away. So I think we may be having a technical glitch here around the answers that are coming through, because I think the answers are quite limited. But let me keep working through, and let's see how this plays out. A couple more questions, if I may. Do you know how many of your products and services have AI? So this is actual knowledge of that particular landscape. So yes, if you do know, maybe, if that's where you stand in the middle, or no. To really know, you need to conduct an AI audit. Again, be intrigued to see what answers we have here. So do you know how many of your products and services have AI embedded in it? I can see you're clicking away. So just give it a little moment and see what the initial results look like. Obviously, this is just a representative sample from some of our attendees today, so it's representative from what we're seeing at the moment. So, okay, no one in the middle. So some 37% of you think, yes, you do. You're fully aware of it, but still a significant number, and this is what I would have expected actually, is no, you need to conduct an AI audit to be clear on understanding how many of your products and services genuinely use AI. And of course, we haven't even explored in this question yet whether that's AI that could amount to high risk or prohibited, or indeed low risk environments, and therefore what the consequential requirements would be for compliance with the proposed new regime. So just another question, if I may. Would the proposals in the draft AI regulation change how you introduce AI into your products? So looking at the life cycle of how you introduce AI into your products. Now, a bit of a loaded question, obviously, because some of you would have recognized the parallels as we talked about with GDPR. So the parallels here in terms of having to think about impact assessments, as we have done with GDPR, having to think about assessments, whether it's legitimate interests or transfers, or assessing what data you have and what the consequences are around ensuring compliance. Would be intrigued to know how you think the proposal in the draft AI regulation will change how you go about introducing AI into your products. So let's just see what sort of representative answers that we have coming through. So a significant amount of you, almost 2/3 of you, suggest that yes, it will impact and change how you introduce AI into your products and services. Excellent. So just a final question again, which I think may help all understand where we are with awareness. So are your business stakeholders aware of the impact of the draft regulation? Yes, quite frankly, if they are aware, or no, and some awareness exercise needs to be undertaken. So your stakeholders, particularly in your businesses, are much more aware of the what's coming down the road and what's being proposed as far as the AI regulation is concerned. So please do click away, and appreciate your patience as we are slightly over time and just approach the end. And I think this is the very last question, so I'd be very intrigued with your answers here. So are your business stakeholders aware of the impact of the draft AI regulation? So let's just see what an initial response looks like. So almost the reverse of what we saw earlier on. Was 2/3 of you are saying no. Obviously, a degree of awareness exercise needing to be undertaken by you. So let me just wrap up, because I know we've come to the end of time. Appreciate those of you who have stuck with us as we've gone just a few minutes over. You know, it's easy to see how the regulation is going to bring about governance and accountability within this new framework. So we will continue to bring you updates on how this develops and what we see happening in this space. Stay tuned. Plug into our Global Data Hub and the content there. There's obviously much more to come from our Global Data Hub on other topical issues too. We've just launched our cyber breach series of webinars. Part 1 was last week. It's a 5-part series, really not to be missed. So please do tune into that. And obviously, we are also continuing to look at the other hot topics of the day, such as the new SECs and adequacy, etc. So a lot happening there as far as that's concerned. But for now, thank you very much for tuning in. So from me, from Debbie, from Helen, thank you for tuning into our webinar today, and we will continue to bring you updates on this topic as it develops. Thank you and goodbye.